Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And thank you for subscribing to my Facebook channel if you have. And we help each other fight foreclosure. That's what we do. This is my private Facebook group, and you're welcome to join us if you're fighting a foreclosure yourself. If you have questions, you can always send me an email. My email address is the number 4, foreclosurehelp777@gmail.com. If you do have any questions, I'll be happy to answer them free of charge, of course. I am not an attorney. I'm just a homeowner who fought foreclosure herself, and I want to help others. So let's talk about today's important topic, shall we? Okay, so today's topic is important because a lot of people send me questions about the difference between a jury trial versus a bench trial. And as you can see from this picture, the verse of the day is Leviticus 19:15. You shall do no injustice in court. You shall not be partial to the poor or defer to the great, but in righteousness shall you judge your neighbor. As you all know, that sometimes some courts are not as easy to deal with the judges as other courts. We're going to talk about the differences between a jury trial versus a bench trial in foreclosures. Okay, so the path to trial. For a non-judicial foreclosure, let's talk about that first. Let's talk about non-judicial foreclosure where the homeowner files a complaint in court, which ends up in the federal court usually. So it's the federal civil litigation path to trial. This path is usually seen in FDCPA cases, RESPA claims, TILA lawsuits, wrongful foreclosure suits, fraud claims, quiet title actions filed separately, federal civil litigation. And this is where the homeowner is the plaintiff and the bank is the defendant. The typical timeline for this: the complaint is filed, the motion to dismiss, you have to survive your claims, an answer is filed then by the defendant, and then discovery begins. Then you have your depositions and document productions, your motions to compel, your expert witnesses sometimes, motions for summary judgment, and denial of your motions for summary judgment. That's what gets you to trial. Settlement discussions begin, you have mediation, and then you have the jury trial or bench trial. So here's an important point, guys. In these types of civil actions, surviving dismissal or summary judgment are major milestones because many cases never reach trial. So the path to trial in a judicial foreclosure defense is way different. So let's talk about the differences. The path is very different because the homeowner is usually defending against a foreclosure complaint rather than acting as plaintiff. So the typical timeline. In a judicial foreclosure, the foreclosure complaint is filed, there's service of process, sometimes there's a motion to dismiss, then the answer is filed with affirmative defenses and counterclaims, then comes discovery phase and mediation or loss mitigation, then comes the motion for summary judgment by the bank, an opposition to summary judgment by the homeowner, and then denial of summary judgment. If you're good at opposing their summary judgment, then the judge can't grant it. And then it goes to trial, usually a bench trial. Now the key difference, and that's true though, because your state court are not going to let you have a jury trial. The key differences between the two paths is this. In federal or civil litigation, the homeowner is often the plaintiff, asserting affirmative claims, seeking damages, and sometimes demanding a jury trial. In a judicial foreclosure, the homeowner is usually defending against foreclosure, fighting summary judgment, raising defenses, and often proceeding towards a bench trial rather than a jury trial. Very important strategic point here: in many judicial foreclosure states, if the bank wins summary judgment, there may never go to trial at all. This makes defeating summary judgment one of the most important critical moments in foreclosure defense litigation. Sometimes surviving summary judgment is itself a major strategic victory. So what is a jury trial? A jury trial means ordinary citizens decide disputed facts in the case while the judge controls the law and the courtroom procedure. That is what a jury trial is. What is a bench trial? A bench trial means that the judge decides everything: the facts, the credibility of the witnesses, admissibility of evidence, and the final ruling. Most foreclosure cases in judicial states are bench trials. They will not give you the option, just so you know. Many judicial foreclosure states do not allow pro se jury trials. This is a very important point because people often misunderstand. In many state court judicial foreclosure actions, especially when proceeding pro se, homeowners will realistically end up before a judge rather than a jury. Foreclosure is often treated as an equitable action, or equitable claims traditionally do not carry the same jury trial rights as legal claims for money damages. Even where a jury demand is technically possible, courts may strike the demand, limit issues presented to a jury, or keep the matter as a bench proceeding. A jury may be more emotional and sympathetic. Jurors may respond strongly to unfair treatment, service misconduct, confusing loan histories, robo-signing, lost paperwork, or stories involving family hardship. So again, this is where you're in a jury trial situation where you're the plaintiff and they're the defendant. A judge may focus more on technical legal defects. Judges are trained to analyze standing, evidence rules, burdens of proof, statute of limitations, chain of title issues, and procedural defects. Highly technical foreclosure defenses may receive more careful analysis from a judge than from jurors unfamiliar with foreclosure law. Jurors can be unpredictable. Some jurors may sympathize with the homeowners. Others may simply think if someone borrowed money, they should pay it back. That risk always exists. Complex securitization or assignment arguments may also confuse jurors if not explained very clearly. Bench trials are usually faster and more structured because bench trials often move more quickly because there is no jury selection, fewer evidentiary delays, and judges are already familiar with foreclosure procedure. This can be an advantage or disadvantage depending on the case. A jury trial can increase pressure on the bank. Banks and servicers sometimes dislike jury trials because jurors may dislike large financial institutions. Emotional testimony may carry weight, and unpredictable verdicts create risk. Even the possibility of a jury trial can sometimes increase settlement leverage. Bench trials can favor strong procedural records. If the homeowner has strong discovery evidence, admissions, standing defects, procedural violations, or statute of limitations defenses, a judge may be the better audience because those issues are heavily legal and procedural. So the best choice depends on the type of case. Again, if you're the plaintiff, you can choose between jury or bench trial. Cases centered on emotional hardship, fraud, harassment, or deceptive conduct may benefit from a jury. Cases centered on technical legal defects, evidence rules, statutes, or procedural errors may favor a bench trial. Good litigation strategy means understanding your claims, your evidence, your court, your judge, and your audience. Here's a real-world example. When a jury reacts to a foreclosure misconduct, in this case you can look up online, guys. It's Wells Fargo NA versus Wolf. This was a Texas case. The case was in 2014, so it's kind of old. And you can see this right here. I won't read the whole opinion here. I will read part of it because it's kind of long. But it says here from the well, let me just read it. It's pretty good. In 2015, a Texas jury awarded homeowners David and Mary Ellen Wolf approximately $5.4 million after finding that Wells Fargo and Carrington Mortgage relied on fraudulent robo-signed foreclosure documents. Now, the issue of mortgage notes being transferred between lien holders and servicers after the mortgage was originated is not a foreign concept at all, but the Wolves, via their neighbor attorney, argued that Wells Fargo violated Texas law. Again, from the Houston Chronicle. Hughes argued that when Wells Fargo retroactively attached the Wolf's mortgage to a securitized trust that was closed and sold to investors 3 years earlier, the bank violated a Texas law that prohibits fraudulent real estate filings. The jury agreed, although State District Judge Mike Engelhardt hadn't formally entered the verdict, and the bank and the mortgage company hadn't said whether they'll appeal. So the case involving the assignment documents was falsified, the chain of title was defective, and the foreclosure paperwork had been improperly executed. The jury reportedly awarded actual damages, emotionally distressed damages, attorney's fees, and punitive damages, and this illustrates an important strategic point. A jury may strongly react to evidence suggesting forged signatures, fabricated documents, deceptive servicing practices, and unfair treatment of homeowners. Jurors often view cases through the lens of fairness and credibility rather than purely technical legal procedure. And of course, that case, they had an attorney doing all the legwork, and attorneys do better when they are used to doing trials. And so that was, I don't think they would have done as well as if they were pro se. Okay, a bench trial judge may focus more narrowly on admissible evidence, standing statutes, and procedural rules rather than emotional outrage. Pro se litigants may face greater challenges in jury trials. Representing yourself before a jury can be significantly more difficult than presenting a case to a judge in a bench trial. Why? Because juries are usually unfamiliar with foreclosure procedure, evidence rules, standing doctrine, securitization issues, and technical legal arguments. A pro se litigant must not only understand the case, they must also explain complicated issues clearly enough for ordinary juries to follow. And that can be difficult without courtroom experience, formal evidentiary training, witness examination skills, or experience presenting arguments to a jury. Okay, also a judge may understand technical legal arguments more quickly than a jury. Jury trials require presentation skills. In many ways, a jury trial is not only about the law, it's also about communication. Jurors evaluate credibility, clarity, organization, confidence, and emotional presentation. Even a legally strong case can struggle if the presentation confuses the jury. So the strategic reality. For some pro se litigants, a bench trial may provide a more focused legal environment, fewer emotional distractions, and a decision marker more familiar with complex foreclosure law. This does not mean jury trials are bad. It just means that the best strategy depends on the claims, the evidence, the courtroom skills of the litigant, and the complexity of the issues involved. Does a jury have to be unanimous? In many civil jury trials, all jurors must agree on the verdict, especially in federal court. However, some state courts allow non-unanimous verdicts in civil cases such as 10 out of 12 jurors or 5 out of 6 jurors. The rules vary depending on the jurisdiction. Why this matters strategically? A unanimous verdict requirement can make jury trials more difficult for both sides. Even one skeptical juror may prevent a verdict or create a hung jury, or force further negotiations. This can create additional leverage during settlement discussions. Bench trials are different. In a bench trial, there is no jury deliberation, no need for unanimity, and the judge alone decides the outcome. This means that one judge, one interpretation of the evidence, and one final ruling. Strategic consideration. Some attorneys believe a jury offers more opportunities for sympathy and persuasion, while a bench trial offers more predictability and legal consistency. But jury trials also carry greater uncertainty because multiple people must agree on the outcome. Jury trials usually must be requested. In most civil cases, a jury trial does not happen automatically. A party must formally demand or request it by filing a jury demand or a demand for a jury trial, or including the demand within the complaint or the answer. If the request is not made on time, the right to a jury trial may be permanently waived. So timing matters. Different courts have different deadlines. Always read your court rules. Can you change from a jury trial to a bench trial? Often, yes. A party who initially requested a jury trial may later decide the case is too technical for jurors. the issues are primarily legal rather than emotional, the evidence is better suited for a judge, or the risks of a jury verdict are too unpredictable. In those situations, the parties may proceed with a bench trial instead. Oh, one more thing, important limitation. In many jurisdictions, once a proper jury demand is made, one party usually cannot unilaterally withdraw without consent, especially if the opposing party relied upon the demand. So you always have to get consent if you're changing your mind. Sometimes both sides must agree, or the court must approve the change, but rules vary by jurisdiction. Why someone might switch to a bench trial? Complicated legal issues. Technical evidence, concern that jurors may become confused. Shorter trial time, lower litigation costs, or belief that the judge better still understands foreclosure law. So there are many reasons to change your mind. And one more thing, a very important reality about jury trials. Jury trials are highly specialized. In a foreclosure-related jury trial, the bank or servicer will most always be represented by an experienced litigation attorneys who are trained in jury selection, witness examination, objections, courtroom procedure, evidence presentation, and persuasive storytelling. Trial work is a skill developed over many years in courtroom experience. And why this matters for pro se homeowners? A homeowner representing themselves may already be under enormous stress and financial pressure. They have emotional strain, unfamiliar legal procedure, and fear of losing their home. Speaking before jurors, introducing evidence properly, questioning witnesses, responding to objections in real time, and following courtroom rules, that can be extremely difficult for someone without litigation experience. Okay, guys, that does it for today's episode. I hope this was informative to y'all fighting foreclosure. And if you have any questions, leave them in the comment section below. And as always, everyone have a blessed day.